This is wasting the court's
Yeah,
time, and it's wasting plaintiff's time.
I don't need to.
What?
I don't need to talk about it. I thought you were asking me.
Well, the problem is maybe I'm
not sure about that case. Good morning, Your Honor. Steve Otherby on behalf of Plaintiff Fixing Housing, 401k.
Erica Ward.
Aaron Wood.
Thank you. You may be seated. Okay, folks, where are we on this case?
Your Honor, we're here for our 7th hearing in this matter. If you recall,
And you might be to 10 by the time you guys get done, but go ahead.
Your Honor. But at the last hearing, we had our motion. It was a motion hearing.
Yes.
And you stopped it, and it essentially became a settlement conference.
Yes.
Nothing came out of that. It didn't settle that day. How about that? After that hearing, the tenants sent 2 notices of repairs, which one of them matches one of the pending motions that's before you. Our response to that motion would apply to the second notice of repairs. And Your Honor, also, I learned on Friday afternoon, I received an email from Donna Tope with the filed correction of defendant's response to plaintiff's motion for summary disposition that was filed on their behalf.
You received what?
I received an email from Donna Tope with what appears to be, and it's a filing. It's called Correction of Defendant's Response to Plaintiff's Motion for Summary Disposition that was filed on their behalf.
Is it in here? I did not. That was on Friday you received it?
I received that on Friday afternoon. And Ms. Tope.
No, I got there.
I may be able to.
Your Honor, I also have the email from Ms. Tope, which it appears like she's still representing the defense.
Okay, go ahead. I scanned it, but it's basically her affidavit, it looks like.
Your Honor, it appears to be a supplemental corrected affidavit by Ms. Tope. It's blamed on a computer glitch from the previous affidavit that she filed in response to landlord's MSD. I have many problems with the filing. At December 19th hearing, you ordered a moratorium on plaintiff's motion or party's motion practice. And it does not appear that they asked you for leave to file this corrected response to our MSD. Tope filed this on behalf of the wards, even though she was required to withdraw from this case, and she did withdraw from this case. Tope's filing in her email, which again, I have the email, which demanded a copy of landlord's MSD. So it appears that she's still acting as counsel on behalf of the tenants. And tenants are responsible for their filings. They can't plead ignorance to this. The filing and Tope's affidavit are dated January 8th. That's 2 days after our last hearing. The proof of service falsely states that it was filed with the court and served on landlord on January 8th. The court stamp shows that it was actually filed on January 14th. Your Honor, I can address the substance of this corrected affidavit. It appears that she's still making the same residential lease argument that, as you recall, Your Honor, you warned the tenants that if they continue to make this argument that they could be subject to sanctions. They made the argument and they continue making the argument.
Let's deal procedurally, I guess, before I get to the substance of it.
I can address the substance.
Well, yeah, I know you can, but I want to try to figure out why this is here.
Okay.
You want me to address that?
Yeah, please.
I had no idea as to procedurally. All I did when we left is said, you know, your affidavit was like glitched, incorrect. You've got stuff. And so I didn't ask her to do anything. She's not representing us. She just said, hey, just so you know, I fixed my affidavit. And that's as a witness, not as a lawyer. I didn't have anything to do with it, and I didn't even realize it would be an issue. I told her that her affidavit was not correct at all. And that is how she followed up. She is not representing us, Your Honor.
This doesn't make much sense to me as to why she did this. She's not here to answer.
I have the email, which it appears that she's still acting on your behalf in this case.
Hold on a second. Can you show, were they CC'd on that, do you know? Or can you show them, and then I want to see the email?
I don't think it's a refiling. I just think it's a refiling of the original one with the correct affidavit. So I don't know
Okay.
the specifics of the law, but to me, it just looks like a corrected, something that she had already filed. Actually, the correction to what we filed.
Mr. and Mrs. Ward, I guess it would be one thing if you had filed something saying, here's the corrected affidavit. And if you went to Ms. Tope and said, this is all wrong.
What was supposed to be a routine follow-up hearing quietly turned into a procedural nightmare that tested the patience of everyone in the courtroom. By the time the parties arrived for what was already the 7th hearing in this case, the judge expected progress or resolution. Instead, she was met with confusion, unexpected filings, and documents she had never authorized. A so-called corrected affidavit appeared in the record without leave of court, without the knowledge of the defendants, and without any clear explanation as to why it was filed at all. As the judge tried to understand how a withdrawn attorney was still submitting documents on behalf of parties who claimed they never reviewed them, the frustration became palpable. Each answer raised more questions, and what should have been a simple procedural clarification turned into a deep concern about fairness, responsibility, and wasted judicial time. The court made it clear that when documents are filed, someone must be accountable, and in this case, accountability was dangerously unclear.
Here's the corrected affidavit, and you guys sign off and you file. That's one thing. This is a whole other thing along when you take it in the context of that email. I don't know why she's still communicating with counsel. It doesn't make any sense to me.
I did not ask her to do that at all. And I understand what you're saying. It would have made sense for her to correct her affidavit and hand it to us so that we could submit it. I have no idea why she did that.
So here's where we get into another thing. She filed this without your permission.
Believe me, I'm staying as far away from as possible.
Did you read the affidavit?
The initial one.
No, I understand the initial one. Did you read this doc?
No, actually, I didn't. I did not.
I did not know.
Updated, I mean, because I didn't even realize that initially when we submitted it, that we submitted something that had pages mixed up.
Your Honor, they're still responsible for their filings.
Yeah, but I don't know if that's their filing.
She mentioned about the pages being mixed up. Their response to our MSD, they are still responsible for their filings. That's all.
No, I understand that, but I don't know how I hold them responsible for things that were filed without their knowledge, is what they're telling me. That's the difficulty I'm having, right? Is that, procedurally, if Ms. Tope came along and filed this, but had gone to them and said, here, this is, I see what you're saying, so I need to correct this. Here's this, I'm going to file this. That might be one thing, but that's not what I'm hearing here. I'm hearing that this was filed. You guys didn't have any knowledge as to its contents.
Correct. I did know that she corrected it after the fact and submitted it after she did it. I had no idea any implications that would come of that.
You had
I hear
knowledge
now
that she
that
did, that she did what?
That she fixed it after the fact, but she never told me that she was.
What does that mean? That you had knowledge that she fixed it after the fact?
She told me she did it after she sent it to them, but it was already done. She never asked me if she could do it.
So after, when was that?
At some point after they received it.
Well, they just got it.
We received it Friday afternoon. Even though it's dated on there January 8th.
Yeah, I would have to look. I don't know.
And then
You have to look at what?
My email.
Look at your email. I want to know.
Actually, there's nothing in here, so she must have just told me that she would fix it. If this is any help in understanding my brain frazzle, I also have a case of strangles at the farm.
Your Honor, I would add in the context that Ms. Tope is still representing them in the circuit court action.
Yes.
My understanding was that we were here today to continue settlement talks and that the settlement that we presented on the 6th was rejected.
Right.
Okay.
We might be. And I may have called the parties back and said, look, where are we? I mean, counsel kind of let me know where his client, but the problem I'm having and what is creating a bit of a difficulty here is that there are documents that are being filed in this action, not by you.
Nor with my permission. I don't know how
Was there anything recently filed in the circuit court action, counsel?
No, Your Honor. Yes, our witness list. Yes.
Right. Okay. But I mean, anything else by Ms. Tope that was.
I filed my witness list and then she filed her witness list hours after.
After. Right.
I can find that date. But to my knowledge, Ms. Tope is still representing the wards in the circuit court action. And it seems like they are still having communication in this case.
Yeah, and the communication.
As the discussion continued, the judge's tone shifted from patient inquiry to visible irritation. She pointed out the real issue. Attorneys and parties were being forced to respond to filings that the defendants themselves claimed they had never seen. This was not just inconvenient. It was fundamentally unfair. The plaintiff's counsel had spent time and resources responding to a document that may never have been authorized, and the court itself was now spending valuable time untangling a mess that never should have existed. The judge emphasized that this type of conduct, whether intentional or careless, undermines the integrity of the process. When she stated plainly that this was wasting both the court's time and the plaintiff's time, the message was unmistakable. Litigation is not a free-for-all, and the courtroom is not a place for unauthorized filings or informal fixes after the fact.
I don't necessarily have a problem with. What I have because I don't know that I could stop that in anybody, but what I do have a problem with is when things are filed before this court, presumably on your behalf, but without your knowledge. That just it. And then counsel has to spend time looking at it and trying to respond to something that you guys didn't file. And you don't even know what it is at this point.
Should I?
No, we just don't have classes.
I don't think either one of them said they've seen it before today. Did you see it, ma'am?
we talked about it, so that she was updating it, but neither one of us read it.
No. I get that there can be these conversations,
Yes.
right? I mean, and I don't have a problem that she was going to update whatever.
Right.
Have you
No.
seen what was filed in court on your behalf?
No,
Do you know where Miss Tope is right now? Because I'm going to tell you, I'm a bit livid, just a bit.
can you take that up with her?
Well,
I'm trying to get
I
out of it.
intend, no, I intend to, but here's the problem. Yes, I don't think the parties, and I'll just say this on the record, I don't think the parties were all that far apart in terms of how this matter could be resolved. That's just this court's view. But I also have these motions before me that I need to rule on. But at each, and so we come back here, regardless of what the parties thought may happen, might not, whatever, right? She then interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, for anybody to do it is a bit appalling. For an attorney to do it is with the court that you have not reviewed or she has not gone through with you and you have not seen. But she's now filed something not as the attorney on your behalf and you have no idea what it is.
I understand. I should have taken her affidavit and had Aaron submit it. That's a correction.
But I'm not going to tell you what you should do because I mean, I haven't looked closely at what she submitted vis-a-vis the other part. But you can't respond to her affidavit.
As a witness, I thought, because she was a witness to the fencing
No,
conditions.
but the affidavit is submitted as part of a motion for summary disposition. So if we go forward with the motion for summary disposition, you don't know what that says. Right?
Right. I mean, I have a general idea, but no, specifically, no.
You don't know what it says.
Correct.
The only general idea you may have is what Miss Tope in the moment told you she was going to do. But you don't know what it says, do you?
No, not specifically.
So if I have counsel respond to the substance of this affidavit, I just want to be clear. You can't respond to the substance of what's been filed.
Oh, I cannot give you the specifics of the substance of what was filed, other than it was the affidavit, and I know in general, as a boarder, what happened with her horse and the injuries sustained due to the fencing. And the witness that she is to the collapsing buildings and the fallen trees and the heavy equipment.
But this is wasting the court's
Yeah,
time
I don't-
and it's wasting plaintiff's time.
I don't need to.
What?
I don't need to talk about it. I thought you were asking me.
Well, the problem is maybe I'm a bit unclear. Counsel receives this on Friday. That requires him to do certain things, increasing the cost to his client. He comes here and then has to spend time in this courtroom making an argument regarding something that you don't know anything about, but are connected enough to the person that filed something on your behalf. That's a problem.
Your Honor, I would just also add, this has been a pattern. We've had hearings set and tenants file motions and send them to me 2 days before the hearing. This is a pattern.
No, I get it. I get that part of it.
Despite her clear frustration, the judge made a decision that surprised many in the room. Instead of ruling immediately on the pending motions, she adjourned the case yet again, setting an 8th court date. But this was no ordinary adjournment. After consulting on ethical concerns, the judge announced that she would issue an order to show cause requiring the former attorney to appear and explain why she should not be held in contempt or sanctioned for filing documents without authority. The seriousness of the moment was unmistakable. The judge warned the defendants that if it was later determined the filing had been made with their knowledge or approval, they too could face consequences. She also directed the plaintiff to prepare detailed billing records for time and costs incurred as a result of this filing. What began as a procedural issue had now escalated into a potential contempt proceeding, underscoring just how seriously the court viewed the misconduct.
And most of that stuff we can sort through, but when that was happening,
I think we got the motion for summary judgment the day we were coming in here. No?
well, you may have gotten it, but I think somebody.
Yeah, and the file, it wasn't noticed for the same day.
I'm gonna let you go ahead and argue your motion. All right, go ahead.
Your Honor, would you like me to address the affidavit?
Yeah, I knew we were gonna get there. Yeah, I'm gonna let you do your motion. It's a fair question as to whether or not.
Your Honor,
Hang on a second. The court's gonna stand in brief recess.
All right. Cook County, Washington State of Michigan, down back confession, the Honorable Judge David.
You may be seated. I'm back in the case of fixed housing 401k plan versus the wards. Here's what I'm going to do, much to your dismay, because I'm going to give you an eighth date. Okay. An eighth date to come back, an eighth time. But I am adjourning the motions for summary disposition. I am also, after some consultation as to some of the ethics that have been involved, which is why I was taking the rather prolonged break, that I'm going to set an order to show cause for Donna Tope to show cause why she should not be held in contempt for the filing of this. I would just place Ms. Ward, I would place you on notice that you have made a specific representation to this court that you had no knowledge of that representation in terms of setting this notice or setting this order to show cause. Counsel for the plaintiff, in the event that the court would award sanctions and or costs, I would need a billing from you, an appropriate billing from you, laying out from certainly the time Friday, time that you received this, what you had to put in to do that, and your work up to that, as well as what other stuff you may have to deal with this being adjourned out 2 weeks to that day. I will then adjourn it for the motions and for the order to show cause to February 3rd at, you wanted me at 2
p.m.
At 2 p.m.
Can I hear again what those two purposes are?
One of the motions that I'd like to rule on at some point, but the other is for an order to show cause as to why Ms. Tope should not be held in contempt of court and or sanctioned.
On that second note, how does that have anything to do with me? And
Oh, it certainly does, because here's going to be part of your problem, as it may be, and that is I will have to make a determination if Ms. Tope gets here and says that that was filed with your full knowledge and authority because you have represented to the contrary. And so I would suspect that when the two of you get here, you are going to be very much at odds.
can I ask one question before you adjourn today?
Yes, ma'am.
Plaintiff's lawyer mentioned that I had reached out with 2 additional complaints, and I just need to understand what my legal process moving forward would be when I have a fence fall over or don't have water, because those weren't additional complaints from the past. Like, I'm still
you
there.
can certainly reach out
I'm
with
just letting you know.
whatever, right, you can reach out with whatever repairs. I certainly would have been in a position to kind of address that today, but I
realize that my landlord is probably not, as usual, going to do anything about it, but I want it documented that, hey, on this date, the wind blew this section of fencing over. It just keeps happening. So that's okay to email him.
you can email him
Okay.
as long as it's you emailing him.
Yeah, it's no motions or anything.
All right.
Thank you, Your Honor.
Sir, was there anything else?
I would just say when you email me, put that it's for this action because Donna Tope is still representing you in the circuit court action. So be clear what you're talking about. Because there are two actions.
So regarding my lease, these things are falling over. Is that correct?
I think what he's trying to say is that you are directing your concern regarding this case,
right,
as opposed to the case that you are represented by Ms. Tope.
No,
because presumably,
so
listen to what I'm saying. That it's regarding this case because presumably, if the complaint were to be in that other case, he would be receiving a communication from Ms. Tope.
Okay.
I'm trying to make sure I'm following.
Yeah, right. Because he can't respond to you in a case in which you are represented by an attorney. So you have to make it clear that this is the case you're dealing with.
Okay.
All right, folks. Thank you.
Thank you.
And so that, I guess one other thing, I was not aware of that filing because it had gotten put into the file and there was no judge's copy that was presented to the court. So it did not come to me.
As the hearing came to a close, the judge addressed a deeper issue that extended beyond a single affidavit. This case, she explained, was stuck in a cycle of last-minute filings, repeated hearings, and blurred boundaries between separate legal actions. She clarified that parties must communicate clearly, must file documents properly, and must respect the limits of representation. The judge allowed the tenants to continue documenting repair issues, but only if communications were clearly tied to the correct case and made directly, not through unauthorized intermediaries. Her final remarks made one thing clear. The court was running out of patience. Justice cannot move forward when procedures are ignored, responsibilities are dodged, and the same issues resurface again and again. This hearing was not just about paperwork. It was about restoring order, clarity, and accountability before the case spiraled any further out of control.